So have you seen this commercial, the one for the meningitis vaccine, where it shows the college-age girl and she calls home. She's got a high fever. She's not doing very well. And it says, parents, something you need to plan for, make sure they have the vaccine. Your kids have this vaccine before they go off to college because they can avoid such terrible complications. Well, this commercial is all about making sure that parents are motivated to protect against one thing. What it makes me think about is parents who have a child at school or in the world that ends up at the health center at the university because they've been injured or they've got a virus or appendicitis or who knows what it is, who come rushing into the college town and go to the health center and find out that, you know what, your baby's all grown up. Hello, and welcome to another episode of Let's Talk Estate Planning. I'm Jim Miskell. This is the podcast where I'm pursuing my dream that everyone has estate planning that protects their family's future and peace of mind and makes them sleep a little bit easier at night, making sure that they've got everything taken care of so that when grief and crisis occurs, your family isn't left scrambling trying to figure out what the heck is going on. So here's the deal. I appreciate you joining the podcast. The podcast is information and education, hopefully a little bit of entertainment. The issues we talk about are really important, but it does not constitute legal advice. You shouldn't take action on anything you hear in my podcast or anybody else's. That's where meeting with a qualified professional to get legal advice about your situation is really important. So this is the disclaimer. I'm a lawyer. You knew I was going to have a disclaimer. Information and education and hopefully a little entertainment. That's what the podcast is all about. When you need legal advice about your situation, you need to get that from a lawyer representing you. Whether you meet with them virtually or in person, that's the next step. That's my disclaimer. Now back to the podcast. You're no longer your child's parent in the sense that once they turn 18, they're adults. What does that mean? That means that mom, dad, you can't tell the dentist to do the fluoride rinse. They have to tell the dentist to do the fluoride rinse. As far as medical care, all those things, they now act for themselves. When children are younger than 18, parents are their natural agents. They're the natural guardian and conservator for that child. When I say guardian, that means all these things about daily life and healthcare. When I say conservator, I mean everything about that child's property, their what the law calls estate. And so the day that child turns 18, they're an adult, you're an adult, you no longer have that relationship. This is why it's critical, and it becomes sort of an unexpected part of my practice in estate planning, to make sure that child, as they turn 18, has authorized parents to continue to act for them through those early years. Before we, as young adults, get a little bit older, have our own families, have marriages or attachments where we have people we want to act for us, most kids aren't grown up at the knell of the clock at midnight on their 18th birthday. So that's why it's really important to make sure, and what I'm talking about is making sure that there's a power of attorney in place and making sure that there's healthcare documents. And when I say healthcare documents, in a lot of states, that's a healthcare proxy or a healthcare power of attorney, which appoints that healthcare agent. In Georgia, we're talking an advance directive for healthcare that appoints that healthcare agent, which is also coupled with the living will idea, those treatment preferences. If somebody becomes gravely ill in a comatose or vegetative state, or they're in a terminal condition, their death is going to occur in a short period of time, it allows you as the maker of the document to say, this is what I want, continue treatment or don't. When I meet with families, and we do a lot of these 18-year-old birthday packages, and let me tell you, kids are excited on their 18th birthday to go see the lawyer and sign documents. But as we do these, a lot of times kids at 18 don't have a strong feeling on the living will piece, and that's fine. You know, those are optional elections you can make. But what's really important is making sure that as those kids go off to college or their first job or whatever it may be, that if something occurs, mom and dad are still probably their best advisors, their best agents, and look out for them better than anybody else. So it's critical to have that power of attorney that appoints them. What's the power of attorney for? The power of attorney is for breaking a lease if the kid needs to leave town, or negotiating a loan or a contract or any of those things on the child's behalf. Or even if something awful happens, like your 18-year-old is crossing the street and gets run over by a Mack truck in the crosswalk, the ability to sue on that child's behalf is contingent upon having this power of attorney. So it's just extends that parental role a little bit farther until the child's actually ready to take it on and appoint other folks that they may feel like are more appropriate as they age and become more mature. So that's the power of attorney part and the healthcare directive part. I do have a fair few clients also who say, Junior went off to college and grades were not very good. I think he's partying a lot. I can't tell, and I don't find anything out until it's too late. And I called the registrar, and the registrar will not talk to me. That's right. Why? Because the child's an adult and the child has the relationship with the university, not the parent. So as we do those 18-year-old birthday packages, we also put into place something that will make sure that parents have the authority to call up the registrar and get the skinny on the grades or any of those other things, which can also become important in any of those situations where the child becomes injured or sick or those sorts of things. And that educational information, what am I talking about? Talking about grades, attendance, enrollment, which classes they enrolled in, all those things may be important. So we want to make sure that there is a waiver signed on that, which is generally not covered by the power of attorney. There's a separate federal statute that covers that. And we want to make sure that we've got that handled as well. So your baby's all grown up, no longer a baby, no longer your child, but probably not really all grown up. When they turn 18, parents of kids who turn 18 need to get this put in place so that they've got a continuing ability to care and make decisions for that child as it becomes necessary, as the child becomes more mature and can sort of take those things over for themselves. So it's a really important part of estate planning that is perhaps unsuspected. We do planning. I say this a lot. I like to say this about this is that we do planning for seniors. I also do planning for high school seniors. So, the Medicaid and the VA benefits and the post-retirement and asset protection and inheritance, that's one end of it. But the other end, which can be just as important for families, is making sure that kids, as they turn 18, still have a good support system in place. Estate planning is really the real family law. That's the way I look at it anyway. Thanks for stopping by, and I will talk to you soon.